Good morning to our respected speakers, faculty members, students, and all our honored guests. I, Vrunda Nilima Sandeep, welcome you all to this seminar, The Estate Administration Process, Challenges, Opportunities, and Best Practices. Our theme for this session is necessity of taking representation from the court. It is an absolute honor to introduce our first distinguished speaker, Dr. Nilima Bhadbhade. She is an eminent legal scholar, consultant, and trainer. Dr. Bhadbhade ma'am holds an LLB, LLM, and PhD in law from Pune University, where she secured the first rank throughout her LLB studies. She practiced litigation in Pune from 1982 to 1993. Then she engaged in full-time academics. She was an associate professor at ILS Law College, Pune till 2016. Her expertise led to her appointment as a member of the expert committee by the Government of India, Ministry of Law and Justice, to examine and propose amendments to the Specific Relief Act 1963. Dr. Bhadbhade ma'am has designed and conducted specialized training workshops on contracting for professionals across various industries. She has also conducted in-house training sessions in several companies. Additionally, she has delivered lectures on participant-specific aspects of contract and contracting, evidence law, consumer protection laws, and intellectual property laws for senior officers, civil servants, and management professionals. Her contributions to legal literature are remarkable, including the revision of 3 editions of Pollock and Mullah's Indian Contract and Specific Relief Acts. She has also written a note on subject of a contract in Halsbury's Laws of India. She has authored Specific Enforcement of Contract Terms, The Tests of Inadequacy and Effective Enforcement, published by LexisNexis. She is also the author of Contract Law in India, published by Kluwer Law International, Hague, and multiple editions of legal monographs published by LexisNexis and Kluwer Law International. Her insights continue to shape the understanding and application of contract law in India. We are privileged to have Dr. Nilima ma'am share her expertise with us. I request Dr. Varsha Khandagre to felicitate Dr. Nilima ma'am. Thank you, ma'am. Now, as we move forward, let me introduce the role and importance of legal representation. Under CPC Section 2, Subsection 2, legal representative has been defined as a person who in law represents the estate of a deceased person and includes any person who intermeddles with the estate of the deceased, and where a party sues or is sued in a representative character, the person on whom the estate devolves on the death of the party so suing or sued. Legal representative has a wider and more inclusive scope and can include within its ambit executors, administrators, and legal heirs as well. Part 8 of the Indian Succession Act 1925 talks about representative title to property of deceased on succession. Section 211 empowers executor or administrator of the property of the deceased to exercise all rights and powers vested in the deceased. Further, Section 212 of the Indian Succession Act 1925 states that in cases of intestacy for claiming right to the property of the deceased in court of justice, letter of administration is required. Section 213 also states that in the cases of succession by will, no person can claim any right as an executor over the property of the deceased without first obtaining legal representation, that is probate of the will. Section 214 says that no court shall pass a decree against or in favor of debtor of a deceased person unless such person has obtained probate or letter of administration or a succession certificate or an heirship certificate. Section 216 highlights that only person having legal representation has the authority to sue, prosecute in any suit or act as the representative of the deceased in the state in which it is issued until the representation is revoked or recalled. The applicability of the sections differ as per the religion of the parties. These provisions establish the need for the legal representation. However, judicial precedents have varied where some decisions held requirement of legal representation before instituting a suit while others do not. Nilima ma'am will elaborate on the significance of these provisions and their relevance in today's era. I request Dr. Nilima Bhadbhade ma'am to conduct the session.
A very good morning to you all, and it's wonderful to have such good response in such a seminar about representation of estates. Advocate Tejas Uhraji, Advocate Srinivas Patwardhan, all the participants of the seminar, it's a great pleasure for me to introduce to you what is this subject of representation. These are of course my thoughts, and you can consider them as thoughts of a teacher, and then I will request Tejas Uhraji and Srinivas Patwardhan to elaborate on these during their session. We are talking here about successors. A simple situation where X dies. X has relatives, very often close relatives like wife, son, daughter, mother, father. Sometimes no close relatives but remoter relatives. If he dies intestate, then the law tells us which relatives will succeed to his property. And that is governed by the personal law of the deceased. If he has made will, then to whom he has given property, those persons will succeed to the property, subject to conditions in the will. And these are the three sections which deserve discussion, which will come up later too. That 104 says that a legatee has vested interest the moment the person dies. We all assume that the will is valid, then only this can happen. Section 211, which says that if an executor is appointed, then the property vests in the executor, and he is an executor from the date of the death, whether he obtains probate or not. And section 332 later says that the consent of the executor is required for completing the title of the legatee. There is case law to suggest that what if the executor doesn't act? Can the legatees act on their own? Can the heirs act if the executor doesn't do anything? I will not go into those details because I'm only talking about what is meant by representative title. So our question is, when do these heirs become owner? We come to this principle in transfer of property law, rather property law, that there cannot be a property without an owner at any time. Somebody has to be the owner of that property, and there can't be an owner without there being existing property. So when does title vest in a person after the death of the deceased? When can he say that I am the owner? When can he say, because I am the owner, I can now transfer it, deal with it, I can make my will? So he considered it is his property. So when does ownership pass? And the second thing is that when can he exercise powers as an owner? Because his being an owner means he can do some things. Number one is he can himself use it, enjoy it exclusively. He can transfer it, subject to the law of transfer of property. He can transfer, sell, mortgage, etc. Then when it comes to estate of a deceased person, he has to collect it, and very often collect it from third parties. And let me tell you, this is the most important part of representation. Can the heirs divide it among themselves, and can they partition? Because that is what they can do as owners. And my view is that irrespective of what the law says, all these can be done by all these heirs and legatees because they are owners. And then we will say, okay, what are the restrictions? First we understand that they are the owners, title vests in them, they are entitled to do everything, but then what are the constraints and why those constraints are there? And as I always give this example, that when an heir goes to the revenue officer to say, enter my name in place of my father or my mother, he's not going there to say, enter my name so that I will become an owner. He goes there where he says, I am the owner, therefore enter my name. So we must understand that property vests immediately. So what is administration of the estate? It means collection, management and distribution of the property of the deceased based on the law of succession that applies to him. It may be intestate or testamentary succession. And the whole question of representation comes because administration is required. Property must reach those who are entitled to it. And this involves identifying the assets, taking inventories of those assets, collecting them, which would include collecting debts from debtors, collecting property from people in possession of property, and so on. So third parties, third persons, or we'll call them strangers. Strangers are involved here because you have to collect property from the strangers. Then custody means keep the property and to manage it. So yes, there is a house, but then can I manage it in the sense, can I spend and recover from the others? Can I give it on rent and recover the rent, maybe on behalf of the others? This is managing the property. Then it also involves selling and transferring, because when property cannot be divided among all, perhaps some properties will have to be sold and then distributed among the heirs. Then identifying the debts, finding out who owes money to the estate, finding out liabilities, for example, litigation liabilities and so on. Then paying off those debts, because it is only after paying that the estate is to be distributed among the heirs. Paying off the liabilities or undertaking those liabilities. Satisfying the legacies, means to whoever property has been given in the will, they should be handed over, or they should get the property into their hands and then distribute the estate remaining of it according to how the estate should go. So administration actually involves all these things. And very often, apart from where probate is considered compulsory, that is in Mumbai, it is good that most heirs will actually distribute it among themselves without even thinking of any representation. Law should least interfere in private matters. So they are able to do it, they effectively do it, there is no dispute, and it can happen. And therefore that brings us to the question, why do we need representation certificates from the court? And I take you back to 1799 and 1802. These are the two laws. The PPT will be circulated to you, which provided at that time, so long ago, that heirs need not apply to courts for permission to take possession as far as can be done without violence. So between themselves they can deal how they want. Second is that the courts are restricted from interference except on a complaint. Complaint means there is a dispute or somebody wants representation, then they can approach. And lastly, it laid down some procedures if there were disputes, because then the courts would come in to decide the matters. So basically what I highlight is that heirs have the freedom to deal with the properties without violence. The Bombay Regulation 8 of 1827, which still applies in Maharashtra and Gujarat, under this law, heirship certificates, Varsa Dakhal Patra, those are given. And it begins by saying in section 1, and I will read out the main part, that whenever a person dies leaving property, whether movable or immovable, the heir or executor, etc., may assume the management or sue for the recovery of the property in conformity with the law or usage applicable to the disposal of the said property without making any previous application to the court to be formally recognized. So even that law, which still applies, recognize it, but as you can see that it is all subject to the law relating to the estate. So I was talking of strangers, that if, for example, the heirs are there and there are so many things in the house and they say you keep this, I keep that, this is possible. You don't need any court order for that. But when there are strangers involved from whom property is to be collected, so they can be debtors who owe money to the deceased, they can be persons holding the property of the deceased, or they can be record keepers of the deceased property, like the revenue record, the record of housing development authorities. The property is mine, but it's recorded there. The property is mine, but it's recorded in the cooperative society, right? So they are, I call them the record keepers. The registration office of the vehicles, for example, they keep the record. Ownership is with one, record is kept with another. Now they all are required to take action when somebody comes and says, give us the money or give us possession of the property. And so if you are that stranger and I come to you and say, give me the property, then naturally there will be questions in your mind. What are those questions? Are these the only heirs? Are these the heirs of the person? Are they really related to that person? Right? Because anyone can come and say, he was my father or my mother. The next is, are they the only heirs? So if 3 people have applied, there can be a 4th heir. If a will is presented, is this the valid will? And is this the last will? So these questions will come to your mind, and then you will say that I don't want to take a risk. So these strangers, please keep them in your mind. So what are these risks which you should perceive? Number one is I will be required to pay over again when the true heir comes. The second is that there will be litigation expenses, because that third person who claims, he will file a suit and I will be required to spend on that litigation. And in some cases, if there has been negligence, etc., there might be a liability to compensate. It is these risks which you do not wish to take. And basically it is because of this reason that if banks and mutual funds, etc., heirs go and claim the money and the amount is small, they will give without the need of a succession certificate. Why? Because they take this risk. They know that for small amounts no one will file litigation. So they are willing to take those risks. For larger amounts they are not willing to take those risks. So firstly, we recognize that there is no legal bar to deal with heirs. That is what banks do for smaller amounts. Some people can take the risk and pay, but they want to cover the risk, and so they say, get a formal recognition that you are the representative of the deceased person, and then I will pay you. So our whole subject of the seminar is to this, formal recognition of the representative. And therefore a court appoints representatives in so many proceedings. One is the probate, letters of administration when there is a will, letters of administration when there is no will, succession certificate and heirship certificate. There are also certificates which some of you may like to read up. They may not be covered here, and that is certificates issued by the Administrator General under the Administrators General Act. And our discussion in today's session will be centered around these 4 certificates mainly. Now the nature of these proceedings is, what is to be told that Nilima Bhadbhade, who has come as heir of somebody, she is the representative, she can go and collect. This is the collect or represent the estate. So she represents the deceased person. This is broadly the nature of the certificate. You do not need a full trial for that. It is enough if prima facie the court is satisfied about it. Why? Because these proceedings do not take away the rights of the true heirs. Okay, they are not final. Probate and letters of administration are at a higher level, and during our sessions, our experts will guide you about it. So there is a procedure, because these certificates are going to be imposed upon the strangers, in the sense that when a representative goes to the stranger may say, I will not pay you, but the stranger cannot say, I don't recognize you, because I am appointed by the court. Okay. So why is this level of recognition given to these representation certificates? It is number one, that there is an application, and then publicity is given to it by issuing public notices, proclamations, citations and so on. And there is an opportunity for anybody means who has interest in the property, to come and oppose. So somebody may come and oppose that this person whose estate is asked for is still alive, is not dead, some other person of that name. So opposition can start from there and come to this question that this will I do not admit, right? So it could be very specific to the property. And based on that, the court will grant or refuse. What powers the court can exercise, that will come through the proceedings. But basically, if the court grants the representation, then we say this person can now deal on behalf of the deceased estate. Now the certificate will have the name of the representative, etc., and it will also have list or details of the properties involved, right? So that if I come to you, please give me the money, you are my banker, you will first see whether my name is there, you will see whether it's the deceased account, and you will see whether the debt, that is the deposit which you must pay me, is located in that certificate or not. Based on that, you can pay. Now what is the effect of the certificate? This effect is of course different across, but broadly I will tell you, and Advocate Srinivas Patwardhan is going to explain this in great detail. One is that it is conclusive as to the representative character of the grantee. So if I come to you with a certificate, you cannot deny that I am the representative, right? You can still say, I won't pay you because I have a set off, because I am entitled to retain the money under the provisions of the contract, right? But you cannot deny that I don't recognize you as the deceased representative. So it does not bind the debtor. It does not confer title on me if I am the grantee. If I have title, I have it. The certificate doesn't give it to me, and it does not guarantee the deceased title. So it doesn't guarantee that the plot which is mentioned in the certificate actually was owned by the deceased. It only gives representation. This is what we remember. So if at all any debtor says we will not pay you, then the representative is required to file a civil suit. Now there is another thing, that an heir who wishes to get himself declared as an heir, declare me that I am the heir of this person and I have a share in the property, just keep a note of something called section 34 of the Specific Relief Act, which is a declaratory suit. Its effect is different. When can it be filed is different, and perhaps it will be touched upon in some of the sessions. But it is something different and you must read about it. So the certificate merely gives the power of representation. The declaratory suit will declare this person as the heir, as the son, as the daughter, having 1/3 share, and so on. The effect of the suit is also very different, and I will just leave it for you to study the difference. Now, the most important part of these certificates is this, that they give discharge and they give indemnity. I will come to the sections later. What is meant by a discharge? So if I have a certificate and I come to you and I say, please pay me the money, the deposit of the deceased person, then if you pay me the money after verifying myself and the debt in good faith, right, then you are discharged. Means if somebody else comes and says, I am the heir, give me the money, you have to say, I have given to the representative, I am not liable. This is meant by discharge. It takes away the liability. The second is indemnity. Indemnity means that if I have received the money from you and then somebody files a suit, you need not pay the money, but what about the expenses you incur for contesting the litigation, the costs which you incur? So indemnity is for covering those costs. It is sad that the provisions in the law do not tell us how much is covered under the indemnity, but indemnity means that the loss will be covered. So these are the effect of making the payment, and that is why banks, mutual funds and everybody asks for the certificates, and that is why people will get the certificate and then make the claim, because those who owe the money, they want the discharge and the indemnity. I will leave these sections. You may note down the number and read them again. So there are some points to ponder, and this is something, both of them are here. I will request them to throw more light on. I look at this from an academic perspective. They will guide you about the practical perspective. That do certificates discharge and give indemnity to persons who merely maintain the record of properties, that is revenue offices, etc. For example, 273, which gives discharge and indemnities for paying their debts and all persons delivering up such property. So it's about handing over possession of property and paying the debt, right? What is revenue record? It is revenue office. It is neither of these. They are only recording the rights. 381, which is about succession certificates, it says it regards all payments made, indemnities regards all payments made or dealings had in good faith in respect of such debts and securities, means those which are listed in the certificate. So it's only for debts. So my question is that do they really give a discharge to all those government, not the government officials, sorry, the government, which acts on the basis of a representation? This is a question we have to ponder. And the next question which I raise is where section 213 applies, that is where the probate is and letters of administration are compulsory, which will be in Mumbai, for example, for our state. Can heirs use and enjoy the property without probate or letters of administration? Just let it be, not get probate. We will enjoy the property. Second, can they collect the rent of the property if the tenant is willing to pay? To collect the rent and the tenant doesn't pay, they will need a probate representation. But if the tenant is willing to pay, can they collect the rent? Can they divide the movables among themselves? Can they effectively transfer movable and immovable properties to willing purchasers? Right? These are the to willing purchasers means very often the purchaser will say get a probate. So everybody wants to get a probate because that sort of clears the title. But can it be done without probate in certain cases? For example, they don't want to wait and probate is going to take a long time. So these are some questions, and I raised that question of 213 because the language is that no right as executor or legatee can be established in any court of justice. The language is that you can't establish it in the court of justice unless you have a probate or letters of administration. Like I said, I look at it from the academic perspective. I have only raised questions. What we have seen is the meaning of representation. I am representing the deceased, so give me the money, recognize me. This is what the person says. And all these certificates enable the representative to do that. There are differences in them. There are reasons why people apply for one rather than the other. And during this session, all these aspects will be covered. Thank you very much.
Thank you, ma'am.